Okay, folks, can I formally welcome everyone here to the Social Development Committee here Thursday morning. Welcome everybody to the room and to the committee. Could I just, as usual, advise people about the protocols around the use of the electronic tablets, and we ask everyone in the room to switch off their electronic devices, telephones and so on. Could I ask any members of the committee to declare any interest relevant to being discussed today? There are none being declared. Moving on to apologies. Any apologies to record? No apologies to record. And we move on to the draft minutes. Draft minutes from the meetings of the 28th and 30th of April. They're at page 5 of your meeting pack, members. Are members content with the minutes for the meetings from the 28th and the 30th of April as drafted? I agree with that. Our personal business, no items to report on. Matters are raising. Just to remind members that we had agreed a press release relating to the inquiry report, and that was subject to some legal advice, as you know. Following consideration of the advice, the clerk had made some minor changes to the press release and informed members of these changes by email. A copy of that advice is tabled for your information. People content enough to note that? Okay. We also have correspondence from the ad hoc committee on the Northern Ireland Public Service Ombudsperson, the bill, the NIPSO bill. That's at page 2 of your tabled items. The ad hoc committee obviously would welcome any views the Committee for Social Development has on the bill. In addition to Executive Departments, the committee may wish to note the listed authorities relating to housing in the charity and voluntary sector which will fall on the remit of the proposed new office of the Ombudsperson, and that's the schedule. If members are content, could I suggest if you could forward any comments you may have to the clerk by 12 p.m. on Wednesday next, that'll be the 20th of May, and then we could agree that or otherwise at the committee on the following day, which will be Thursday the 21st. So this is in order, like if people have any views or comments they want to make, it will be forwarded to the clerk here by Wednesday next at 12 p.m. to allow that to be included in the committee pack. And people may not wish to do that, or may be doing it through other committees and so on. Alright, so just refer your attention to that. Okay, members, moving on to the items, the update on the new housing multiple occupation bill, and we have Rachel here this morning to brief the committee on that. Could I formally welcome again to the committee Steve Martin, David Grimley and Ronan Murphy. These are all very welcome, gentlemen. The part of the paper, members, is on page 15 of your pack. And without any further ado then, could I just ask you and your colleagues just to take the committee through your paper.
Good morning, Chair. Thank you. Thanks for the opportunity of updating you on where we are on a bill to improve regulation of houses and multiple occupation. HMOs are an important part of the housing mix in Northern Ireland and can provide affordable rented housing for a range of tenants, including students, migrant workers and single people on low incomes in particular. Because of the higher risks of living in an HMO, they are subjected to a greater level of regulation than other rented housing. The current HMO registration scheme is produced and operated by the Housing Executive. We undertook a fundamental review of the current system in late 2012 and found a number of weaknesses, not least around the difficulty in identifying HMOs and in the approach to enforcing management and physical standards. We reported the outcome of the public consultation on the fundamental review to the committee in 2013, and at that time committee members raised concerns with the present system and asked for the new system to be more robust. HMOs is a complex area of policy and law, and since our last committee briefing on this issue, we've been refining our thinking, identifying lessons learned from other HMO regulatory systems and working with our legal advisors to draft a bill. The drafting process is almost complete, and the Minister intends, subject to executive approval, to introduce the bill in the Assembly before the summer recess. The key aim of the bill is to better protect tenants living in HMOs, and the bill will do this by requiring landlords to meet important standards on quality and safety before an HMO is let, to link this licensing system with the planning and building control systems to reduce the scope for gaps in oversight to be exploited, and by updating important physical and management standards. The revised system will also allow regulation to be targeted in a way that is proportionate to the risk presented. Because of the importance of linking HMO regulation with other critical local government functions, such as planning, building control and environmental health, we feel that the new system will work most effectively if responsibility for it sits with district councils. I just asked David briefly, Chair, if it's okay just to give members an overview of the key proposals in the bill.
The new HMO bill consists of 90 clauses and 7 schedules, which contain a mixture of the best practices in other jurisdictions and a number of new policy proposals taking account of comments received from the consultation exercise. New provisions are designed to be straightforward, with the intention of making the complex and technical subject as clear and informative as possible, and whilst also allowing the system to be easily administered and operated by councils, with the Department retaining overarching policy responsibility. It may be helpful for the committee if I spend a few minutes outlining the key provisions in the bill. The introduction of a new HMO definition and associated exemptions will provide clarification and guidance on what is or is not to be classed as a HMO. In the bill, the meaning of a house in multiple occupation is a building or part of a building that is classed as living accommodation occupied by 3 or more persons who are all not members of the same family or of one or other of 2 families in specific types of accommodation with use of prescriptive basic amenities. The bill specifies that only rented properties are to be included as HMOs, that a fundamental requirement for designation as a HMO will be shared living. People count as occupants only if the accommodation is their only or main residence. It also specifies the list of persons who will not count in the determination of a HMO and expands it to include others outside the standard family relationship, such as domestic help and some carers. It also specifies that living accommodation which ceases to operate as a HMO because of an occupancy level has reduced should continue to be treated as a HMO for the entire licensing period for the purposes of regulatory activity. Under the licensing scheme, then, a monetary licensing scheme will introduce HMO licensing and will bring Northern Ireland into line with other UK jurisdictions. A separate clause in the bill will ensure an application for a HMO licence cannot be determined unless living accommodation occupied as a HMO has planning permission. This will reduce the possibility of over-provision in the locality in which the HMO is situated. A HMO inspection will ensure the property is not overcrowded and has suitable amenities and facilities for the number of people occupying it. Landlords will be required to apply for a licence to rent the home out lawfully, with licences granted subject to management conditions and conditions requiring any necessary work required to meet current amenity or safety standards. The bill will retain the duration for a licence similar to that of the current scheme, which is 5 years, with licences of shorter duration being granted only in those cases where the Council is satisfied that a justification for the shorter period exists. The current definition of HMOs has been criticised as being too wide and bringing houses into HMO regulation where it is not warranted. The bill provides for exemptions from the licensing requirement where there is some other form of statutory regulation which is acceptable to the Department, or because of the purpose to which the HMO is put, the risk to its occupants is reduced to a level where regulation is not needed. As a result of the concerns raised during the consultation, the bill will now include a fit and proper person test. This clause specifies material which the Council shall have regard to when deciding if the applicant or applicant's agent is a fit and proper person to hold a licence and to operate the HMO. This will ensure that those individuals who are unsuitable to hold a licence and operate a HMO are identified at the earliest opportunity from doing so. The HMO legislation does not currently provide for information to be obtained for statutory and non-statutory bodies for the purpose of HMO identification. A clause in the bill will open statutory information sharing gateways with a number of government and non-government organisations and bodies. Gateways will provide for relevant information to be sent from appropriate sources to assist in the identification and regulation of HMOs. Having a more robust method of identification will provide a firmer basis for the effective regulation of HMOs. The sharing of information clauses will also permit the Council to check with PSNI, other government agencies, to ascertain if the applicant has any relevant convictions, since the HMO operator would be in a position of trust. If the HMO is subject to any other form of regulation, the Council may wish to approach the relevant regulatory authority for their comments. This would usually focus on the applicant's record of maintaining standards and the response if concerns are raised. The introduction of greater and more comprehensive enforcement powers will also ensure that any deviation from the licensing system is penalised in a timely and proportionate manner. The findings from the review considered it unacceptable that the fines imposed by courts appear not to serve either as a deterrent or an incentive to HMO owners to comply with regulatory requirements. The lack of other options leaves a deficit in the options to deal with many non-compliant situations. Additionally, the time and effort involved in taking court action is not justified by the penalties awarded. So the bill has included the power for Council to use fixed penalty notices, which will run alongside criminal offences and sanctions. Introducing fines is a practical alternative which will provide a more cost-effective and less time-consuming means of enforcing legislation with benefits for both councils and occupiers. Councils will also be given powers to obtain information from various specified persons in the House. It can require any occupier to disclose the nature of their relationship with any other occupier, where the information is required to determine whether the accommodation is a HMO that requires to be licensed. The bill creates a power for the Department to bring forward regulations approving a code of practice laying down the standard of conduct and practice to be followed with regard to the management of HMOs. Moving forward then, the Department intend to publish guidance for the licensing scheme for councils and landlords to help them meet the requirements of the regulations. Councils will be free to decide how best to deploy these in the context of departmental guidance. With the enabling powers established in the bill, the detailed administration of the new arrangements will be set out in regulations, with the Assembly being given the opportunity to consider the issues. Subject to the successful passage of the bill, councils will thereafter need some time to complete the preparations necessary to administer the new licensing scheme. Therefore, the main provisions of the bill will come into operation on a date appointed in an order made by the Department, following liaison and agreement with councils.
Okay, Steve, thank you, David. Before bringing members, could I just raise a couple of points? I mean, just based on my own previous experience and other members' experience as well in different constituencies, but certainly my own experience in South Belfast, that previous subject plans around HMOs had restricted, identified zones first of all, then restricted the numbers of HMOs permissible in those areas. Some cases 30%, some cases 10% in a street. And I don't think when the subject plan came out, I don't think there was one street in any of those zones which were not already oversubscribed. I don't think there was actually one. So the subject plan was fatally flawed in my view from the outset. They then had a shocking record of non-compliance. The housing executive was the body supposed to go and identify where these HMOs were and then to get them regulated and identified. That never happened. I was told as far back as 2008 or 2009 that it wouldn't happen to 2013. It still hasn't happened. So there's still not yet a full register of HMOs. Now, I think, David, you made the point earlier on that this is about moving forward. I'd be very deeply concerned about, for example, North Belfast and other parts of the city, but taking North Belfast, given the university development, I would be very, very worried for communities over there which will find their communities completely and utterly overturned within a very short period of time. We had the shocking example of very unscrupulous developers, and they're not all the same, but there are some very professional, very, really well-intentioned and developers of great integrity, so I'm not prodding everybody or landlords for that matter. But we did have people literally pestering older people, going around knocking their door routinely, offering them basically good money to move out of their house so that they could buy them and take them over, transform them into HMOs. And we saw the result of that in the Holy Land and other surrounding neighbourhoods. So how do we guard against that type of unscrupulous activity in the future? Because we also have to try to sustain communities and help communities sustain themselves writ large throughout all of the executive and various departments' policies. It is about sustaining communities, about helping people, it's about empowering people. I would fear that if you have an even more lighter touch in respect to this, then you will certainly effectively destroy the community bases of quite large swathes, potentially. And I don't want to be putting fear in this, but I saw the example in South Belfast, so I'm speaking directly from experience. I had the opportunity to go and speak to people like Sammy when he's another minister wearing another hat, even around that when planning officers were actually directing people in the areas in South Belfast and other areas for their development. I mean, I had to raise that with the minister at the time, which he was then, Sammy Wilson. So, very direct negative experience on this issue, and I certainly wouldn't want to be putting my hand on legislation which allows that to happen all over again without it being unfettered. So I have to say, I'd need to be satisfied. That's just me, but I mean, obviously, I think there'd be a lot of members in the House who would be concerned about the impact of this on local communities. So, what assurances can we get that the regulations coming in for this now will actually be substantially better than what was there in the past?
Chairman, can I just follow up, because an important question, and it was something that was said during the briefing and is in the brief. There isn't any indication in this that councils will be enabled to limit the number of licences which are granted a certain area, and you're still falling back on the argument that, well, a licence will only be granted if planning permission has been given. But you've highlighted the problem. The planning doesn't stop the congregation of this, of houses. So if the planning system still allows houses to be turned into houses of multiple occupation, then it's, unless the person's not a fit person or the property is not fit, then a licence will be granted. At least that's what I took up from you. Or is there going to be the potential for councils to say, it doesn't matter whether the planners say that that house can be a house in multiple occupation, we can still limit the number of licences that we grant in an area because of the kind of reasons that you have given. You don't want to disrupt the community.
Okay.
If I can answer that, well, the licensing is linked to planning, and we've taken account of the subject plan which the DOE currently have in operation. So if anyone, our landlord, applies for a licence, the council will then take account of a certain threshold per area of the number of HMOs that are in an area, which the HMO subject plan currently has, I think it's 30% in their subject plan. So this new bill will take account of that, and particularly where you mentioned earlier, Chair, about the new university moving into North Belfast in that area for new accommodation, and that this new bill will take account of stopping those the same thing that has probably happened in the Holy Lands from happening, based on the fact that it's linked to planning.
But I mean, if we, according to the report, I mean, the latest executive figures would tell us that there are 5,225 registered, possibly up to 500. Probably 30,000 people living in these accommodations. Now, they may well be real accommodation and all the rest of it, but it's different. The other side of the, notwithstanding the quality, hopefully it's very good quality and the good tenancies and all the rest of that, but at each side of the community. And if you're taking account of the existing subject plan, then you're fatally flawed before you start. That'd be my view. So, because you're starting from a failed premise. So, you know, there's no protection. I see no protection in that whatsoever. If you're saying you would take account of the existing subject plan. From day one, as I made the point in the opening remarks, from day one of the subject plan, I can't even remember what year that was published, maybe 2007 or something, quite a while ago. I don't think it was any street in that zone or no zone which hadn't already been oversubscribed. So, how do we start from that?
Chair, if I can come in, I think that the problem is, and the problem in the past was when the subject plan was, as far as we understand it, when the subject plan was introduced, it was too late for South Belfast. The issue in North Belfast will be, it's making sure there's proper join up, as David said. The subject plan limits the number of HMOs in an area, but when it was introduced in South Belfast, there were already too many. In North Belfast, that's not the case. And there are two key issues here. The first one is the link between the HMO Regulatory Authority, which is the councils, is also the planning authority. And the difficulty in the past was there was that proper link between the housing executive as the HMO regulator and the council as the or DOE in terms of the planning service wasn't as effective as it should be. Having this in one body will improve that link. So that's a critical point. The second point is that the having to have a licence before you operate an HMO. At the minute, you operate an HMO and then you apply to be registered. You will have to have a licence to legally operate an HMO, and then one of the conditions is planning permission. If this system had been in place 20 years ago, we shouldn't have got to the place where we were in the Holy Land. But the problem was when the subject plan was introduced, the stable door was open and the horse had bolted. This is to try and prevent that happening again. And we'll certainly take from this that we need to have a further conversation. We've obviously been talking to planning policy colleagues in DOE. We also need to have a further conversation just to make sure that this system is as tight as it can be. But our sense now is that this system, if properly implemented, should prevent a Holy Land situation happening again with a saturation of HMOs in one locality.
Could you also reflect on, before bringing other members in, because there's another problem there with there are properties which wouldn't be identified as HMO, because they're not officially HMOs. So, but they could be in the same street. The ordinary person would see that as HMO, it's rented accommodation, it's transient population. So that adds to the problem.
Yes.
If you know what I mean, the ordinary punter doesn't distinguish between a HMO and a bedsit, or 3 or 4 people living in a set of flats, if you know what I mean. So I would like to know how those dovetail, because the regulation is really only about the standard and fitness and all the rest. It's not about the numbers. It's not about the penetration of a particular area or the tipping the balance from a residential community and the transient population. So I'd be keen to know how those 2 issues would dovetail as well in terms of overall governance of it.
Can I come back on that, Chair?
Surely.
I think the key issue at the minute is the definition of what is an HMO is too unclear. It's too much open to interpretation. One of the things that we're really trying to do here is make it very clear what an HMO is. To make it clear that before operating an HMO, it needs to be properly licensed, and to be licensed, you need to have planning permission. So it's trying to join up the dots and trying to be much clearer about what an HMO is. Because at the minute, that just isn't very clear, and that's a fundamental weakness in the system.
Okay, Stephen, thanks for that. Fra.
Sure, and thanks for the presentation. And like Alec, I remember going back to the day when Margaret Ritchie was the minister, and there was regulations or legislation brought in. I actually remember talking to Sammy back. What is the saying back in the day when there was new legislation coming in? I actually remember at that time that many residents and community organisations felt that finally there was a move being made to try and deal with the serious problem that existed out there in relation to HMOs. But as Alex says, you never seem to get some of the things. There was, I think it's a guy called Ty Wade, was the Bureau in the Housing Executive at the time. And one of the things that he had said, whilst Alex is talking about 5,200 HMOs, that fell far short of the actual figure that's out there, that they were never able to, and he said there could be thousands more out there that are operating illegally, and maybe you could comment on that and how we get the bottom of it. And I think we have an opportunity here, not only to update legislation, but when it does go to council, to arm the council with the proper weapons to be able to effectively deal with everything. Because I think one of the things that we have done in the past as past legislation that near enough tied the hands of council in dealing with conditions and dealing with especially around the private rented sector. What I'm thinking of, especially in terms of university, there are areas that are already under pressure. And I'm just thinking of in that lower North Belfast, the likes of the Taggers Bay, the Limestone Road, New Lodge, and across there that are already under pressure that could fall foul of the HMO developers if we don't put protections in to try and protect what is probably the oldest communities in Belfast. And I do think that there needs to be proper legislation and brought in to deal with the HMOs in terms of the conditions that exists and the amount of people that are in each of houses. Could you give us a wee timeline of how long it will be before this runs through the procedure till it comes to committee and the thing? And have you, when you were drawing up the initial bill, spoke to any organisations or people to try and give you an idea of what they believed? I'm talking about councils and talking about housing providers and housing organisations to give you an idea of what they believe should be in the bill.
Okay. In terms of timetable, we're working very hard to try and make sure that the bill goes to the executive in the next couple of weeks. So if it's approved, then introduced before the summer, hopefully introduction in summer and second stage before the summer, and that will then give the committee the opportunity to do its consultation before committee stage, hopefully in the autumn, subject to your other timetable arrangements. As David said, it's really important that we make sure that councils are ready for whenever, if the legislation is passed, that councils are ready to implement it. So we have been talking to the two councils most affected, where there are concentrations of HMOs, that's Belfast, and probably slightly less, but we still had some conversations with Causeway Coast and Glens. We're re-engaging again with them on this to make sure that we are lined up. And on the point of who have we spoken to, we did the consultation in 2012-13. We had 53 responses. And since then we've been engaging with planning, fire service, councils, the kind of key agencies that we needed to engage with to draft the bill. So we've had engagement. We'd like to do more, and we will do more before the committee stage, hopefully in the autumn. And on the points that you raised, that Mr McCann raised first, Chair, I think fundamentally the kind of key planks of this bill are firstly making sure it's clear what an HMO is, and we've learned very much from the experiences in Scotland and England, and Ronan and David have been in both Scotland and England and talking to colleagues there to learn from, and the Scottish local authorities have been really helpful in identifying for us what's worked well and what hasn't in Scotland, because they've had a licensing system for quite a while, so definition was key. Second thing is making sure that there's a proper licensing system and that councils have powers to enforce. And the fixed penalty notices, the courts have been a bit lenient in terms of when matters have been brought to them. So having fixed penalty notices available to councils acts as a more immediate deterrent, which is really important. The fact that there's join-up with planning, building control and environmental health is absolutely critical, and that there are powers in this bill to make sure that information can be shared. So basically what we're trying to do is make it clear what an HMO is, have a proper licensing system and minimise the number of gaps, reduce the gaps that there are that can be exploited, and join up the dots more effectively to provide better protections for people.
Okay, and is there any idea in total how many there is? Or is that still...
Well, I mean, the Housing Executive is currently the HMO regulator. The figures that they provided of 5,500, they believe is short, but they're unable to provide us with figures on what the number of HMOs that are acting outside the law at the minute.
Yeah, I remember at the time also that there were serious problems in around Dungannon and places like that, the HMO. And obviously it'll take on, but it was just the fixed penalties. It has to be severe enough to ensure that you get a reaction. I think the problem with the fines in courts is that they just took it in the chin and walked away from it. And the other thing is that a number of years ago there was regulations that brought in that raised the age in terms of housing benefit from 25 to 35 and put it in the assured room allowance. And where does that fit into HMOs? Because sometimes you have houses under the assured room that may have 5 people living in one house.
Yeah, I mean, that's one of the key things in terms of the bill, is making sure that there are provision to share information. So if the Housing Executive has information on housing benefit, that it should be able to share that with councils for the proper enforcement of HMO legislation, because that information exists. The Housing Executive know if there are 5 different housing benefit claims going into a house, that it's going to be an HMO.
But see the shared room allowance in terms of people moving into the house they go in for the under 35s. Is that classified as a HMO? Because I can't remember at the time if it was, and it fell under what it was at the time. I can't remember.
It's classified depending on the numbers that are in the house, and under the new definition that we're introducing in the new bill, if there's 3 or more persons that are sharing facilities, sharing amenities, they would be classed as a HMO. And that's pretty similar to what they have at the moment. But it's more stringent and more robust. The new bill that we're introducing, and a lot of the new legislation, statutory legislation that's coming in to make sure that the management facilities and that in the HMOs are going to be regulated properly and the health and safety issues are covered.
And fixed penalty, what are you talking about?
I don't think the level of fine has been set yet, but I mean the powers that councils currently have around the private rented sector, fixed penalties are generally around £500. Councils, in implementing that system, have tended to date to try and use an encouragement kind of approach with landlords, and have tried to encourage them rather than issue a fixed penalty. But some councils are starting to do that. So there's a progressive approach: encouragement, they don't act; fixed penalty, they don't act; court. So at least there's then a sequence, and there's much more of powers for councils to act early, because court can take up to 2 years by the time that it works through the system, and it's not a sufficient deterrent.
Yeah, if it can come in, the average fine is this year has been around £292 when a landlord is taken to court. So introducing the fixed penalties, at least they can be dealt with quicker, and it's better value for money. Looking at going forward using fixed penalties, and fixed penalty notices are already in place under landlord registration, tenancy deposit. So, you know, it fits in well with what the council are already doing.
Do we have those figures of people who were fined? And obviously we're able to quote £280. Have we got the
It's an average figure just for the amount of people.
We can provide figures on and this is on the number of court cases there have been in HMOs. We can provide the information that we have. Yeah.
If I can maybe expand on that slightly, being involved in the draft process as well, it's a staggered approach throughout the bill as to the offences. There's obviously more serious offences for the more serious or more serious penalties associated with them. So our fixed penalty notice, obviously this is still in the drafting stage, but we've taken it in line with the criminal penalties that are in existence at the minute. So the maximum fine for unlicensed HMO under the current registration system is £20,000, which we're carrying forward into the new bill. But it also monitors other jurisdictions, so we think that's a fair enough amount, although obviously the court action hasn't resulted in that. So our fixed penalty notices for those sorts of offences would be £5,000, which is obviously not as much as the statutory maximum for a criminal offence, but it's still significantly more than has been received through the court action at the minute. So we think that's, it's a quick fix in that it will deal with the problem immediately. It will ensure that the tenant gets the work done to the property if there's something untoward about it, and it ensures then that there's compliance through the owner and the manager of the property.
Okay, thank you, Salma.
Okay. Can we just start with the last point you've made? The fixed penalty notices, will there be the same condition attached to the fixed penalty notices as what there would be to the revocation of the licence, i.e. that a reasonable time has to be given to remedy any defects for which a fixed penalty notice will be applied?
Yeah, there's discretion upon the councils, obviously, as to which of these actions they use, but we're hoping that they will use their discretion and treat every case as an individual. But with going in, they have the ability to set the time period involved. So if it's a more serious issue and requires, more serious work requirements to be carried out, then obviously they'll have the opportunity to do so through that.
Okay. But it will be up for the council to deem what a reasonable time is. I mean, for example, it may well be if there's structural, though I can't understand why a licence would be given in the situation where there's serious structural things that have to be addressed, you require more time than, say, where there's antisocial behaviour by the tenants. So that will not be specified in the regulations or anything by the department. That will be up for councils to make a decision about.
Councils make a decision.
And if I can just come in on that, in terms of the landlord registration and tenancy deposit issue, the councils have used discretion. So they've generally given landlords an opportunity to remedy the situation, and then only if they haven't remedied within a reasonable period of time have taken a fixed penalty notice approach. So we would expect them to do the same.
It's just that the fixed penalty notice seems to be a great idea until you then hear all the qualifications attached to it, where you could find that people still are living in the same conditions for some time, or neighbours are having to put up with unreasonable behaviour for some time. If councils set that time limit to be quite long, and for the revocation of the licence, the court process really isn't an answer, is it? Because it's just so long. This is transferring from the housing executive to the councils, and I think that's probably an admission of the failure of the housing executive on yet another function which it carries out. But there were costs involved in that. Will the housing executive budget be adjusted to make available to the councils the resources which are attached to it, and how will you then decide to apportion those resources from, because there are probably 3 councils that are most affected, Londonderry, Causeway Coast and Glens and Belfast. How will that be determined?
Okay, we're going to use there's been a due diligence exercise carried out as part of the reform of the local government process, which has identified the resources currently expended in the housing executive. So that's our starting point. We need then to a discussion, which we're starting to have with councils around and NILGA around, well, what is a reasonable apportionment. In the longer term, our aspiration is that the licensing fee will cover the totality of the cost of administering HMOs, but for the initial period of the first few years, that won't be the case. And the housing executive currently get are grant aided to deliver that function. So that grant aid plus the licence fee plus any fixed penalties will be available to the councils, and we'll go through a dialogue process with them to make sure that it's apportioned fairly across and adjust as necessary in the first few years.
So, and I was just going to ask that question, how have the resources which is it the resources that the housing executive currently decide to put into it, which are clearly inadequate because they don't enforce the legislation properly, or was there a fixed amount given to the housing executive? So you're saying the housing executive were given a fixed amount of money. They will no longer be given that, and councils will be given it?
Yes, the money that is used currently for HMO regulation would transfer to councils, plus any licensing fees, plus the fixed penalty notice, and then there may be a gap which we'll need to get into discussion with.
But given that the housing executive don't spend any money or very little money on it, because, it's evident by the lack of action by them. And if this function is being transferred, probably you're spending even less money. Is that how you're going to determine the money that goes to the councils for this?
That'll be the basis for it, but then we're really keen to get into dialogue with councils about what they think they will need and identify if there is any gap, and then look to plug that gap.
Right. Well, I do think that's an important issue, Mr. Chairman, that it's not just the money, because we know that the housing executives don't do the job properly, and I suspect they've never put the resources into it that they were required to put to it, which is one of the reasons why we have such a poor record from the housing executive. But councils should not be penalised then, just because the housing executive decided to spend no money on it. That then a deflated figure is handed over to the council. I mean, I would hope that what the department would do here is make an assessment of what should have been spent on it, adjust the housing executive budget accordingly to make sure that councils are properly resourced. Otherwise, you're going to get the same thing all over again, where councils are either being pushed to have to find the money or the job's not done properly. Can I just, there's one point here where the licence will be for 5 years, but it might be given for a shorter period of time. And I must say I was struck by the reason. Such justification might relate to the standards of living accommodation, e.g. where it is considered suitable for occupation at the time the application is granted, but unlikely to remain suitable for an extended period. Now, Are you really saying that councils will be permitted to give licences for accommodation which is so dodgy that within a year it might no longer qualify?
Well, there may be the case that they may have to restrict it. One may be due to fit and proper person. Another one may be due to their findings from the inspection. But that would have to be taken forward really with the councils and at their discretion. It seems to be, and it appears that seems to be the case in Scotland, that it's 5 years, but if they feel that there's a possibility that a HMO licence is required for a certain type of accommodation, that they would give it for a lesser period. So we've looked at that and we've taken that on board.
Can you give us an example of a house? Can you give us an example of a house
If I
that
can
might
expand
qualify
on that
today?
as well, another reason behind drawn from the Scottish legislation was it's well known, obviously, that there's going to be quite a bit of student accommodation built in different areas with the change in the move from Ulster University into Belfast. The logic behind that was if the introduction of the bill comes before that point, there will be people that are maybe in a position to accommodate those people within HMOs, but knowing that the student accommodation is then going to follow that, you might not want to oversaturate the area and say, well, we'll grant you a licence for 3 years and then that's student accommodation and we'll have to review it. And that was the logic. It's to make it flexible for the councils to use as well, in that they're not tying people down to a longer term and then creating problems further down the line. So it's not really to do with the structure of the property or a dodgy property, as we thought. It was more knowing that there's quite a few cultural changes coming to Belfast and the wider Northern Ireland area in the next few years.
Your briefing note says it might relate to the standards of the living accommodation. Now, I really can't think of any living accommodation that would, either the licence is going to be granted on fairly flimsy grounds, or I can't think of accommodation that would deteriorate so badly within a period of a year. But that's the example that's been given. I mean, I can take the example that you've given there, and that does seem reasonable, but this does not seem. It seems to me like a charter almost for saying, well, look, you know, we're not going to be all that. We might do it on a year-to-year basis, but we're not going to be all that tight about the standard accommodation, which I thought the licensing system was meant to address.
Chair, I think we'll look again at that point and reflect on Mr. Wilson's views.
Okay. And you see, you'd mentioned, or maybe David, it was you, had said that when it comes to the fit and proper test, the council shall have regard to, and there's a list of things.
Yes,
so
statutory
those
criteria.
don't necessarily prevent someone from being granted a licence. The council simply has to have regard to them. Is that right?
The fit and proper person will be set in statutory criteria, and that will be up to the council to make a decision based on using the sharing of information clauses with other public bodies to determine whether that person should be declared as fit and proper to manage a HMO.
But if, for example, somebody had defrauded tenants in the past, that would not necessarily prevent them from getting a licence, because all you have to do is have regard to the circumstances.
I think we would have to leave it to the discretion of the council, because there would be a lot of information available to the council, and it would be for them to make a decision as to whether they thought the person was fit and proper to manage the
If I
accommodation.
perhaps come in on that, I mean, I think the fundamental issue is we can't fetter the discretion of councils to make individual judgments in individual cases, because then we would be sort of running counter to, because essentially this is determining somebody's, you know, it kind of links to human rights in terms of right to property and so on. So we've got to give councils enough discretion to make decisions based on individual cases. So we tried to strike the balance. If the committee feel that we haven't got the balance right, we can have a look at it again. But we're trying to strike the balance between giving councils enough direction in terms of what is expected without fettering their discretion to make decisions on individual cases based on individual situations.
Well, I mean, I can understand it, you know, where someone has maybe got in a fight on some occasions, has got a conviction for GBH, but it's only a one-off, and it was back some time ago. Should that prevent them from being a landlord? But I just wonder if, having regard to whatever the offence, if on the other hand, they've got a record of going around beating up tenants who don't pay their rent or whatever, that's a totally different thing. Is that, are you happy that that phrase is sufficient to allow councils to make that distinction, or is it challengeable if it's as woolly as that?
But when we were drafting the bill, it was a decision-making process. Obviously, we want the councils to have discretion, because when you're drafting legislation, you can't account for, you can't think of almost every scenario. But as you rightly said, there are more serious offences than others. So if we had put in, instead of a regard, must class these people as not fit and proper, then those with more, spent convictions or things that may have happened quite a bit in the past and have shown that they've reformed their character, or lesser offences, that would rule them out of being a fit and proper person, which is not necessarily what we want to do either. We have to leave it to the judgment of the councils at the time. And as you say, if there's a record there of defrauding tenants, or as you say, intimidation or something that's recurring, then those sort of people you would think would be ruled out automatically. And the councils would have to make that decision on the ground.
Well, and I don't know enough about the law, but all I do want to make sure is that it's not left so woolly that someone who has refused a licence to be a landlord can turn to the legislation and say, well, actually, look, the council has been far too hard on me here, and the judge or the courts then uphold the right. If you're happy that the language of it permits or prevents that, that's fine. But
that current set criteria for fit and proper person is currently operated in Scotland, and we looked at the best practices across jurisdictions, and there was no issue with it. But still, in all, it has to be down to whoever is administrator of the system, and they have to they have to have the discretion to make that decision.
But I think what we can do, Chair, is just check with our legal advisors if there's any scope, without breaching kind of human rights, of going a little bit further. And secondly, in advance of the committee stage, we can re-engage with our Scottish colleagues to see if we can provide the committee stage with some examples of how they've applied a fit and proper person. We're very much drawn on the Scottish model here.
Tommy, happy enough you've noted hands hard before we move off to other places, perhaps? Gregor.
Yeah, I think that it's obvious from the questions before now that some of us would be concerned about the ability to circumvent under the new bill. So, taking that into account, you've said that there's approximately 500 not registered currently, and yet you've been able to identify, which is probably fairly standard knowledge, where you would expect them to be, quite understandably, both in Holy Anne's in Belfast and Coleraine Uni. So what steps under the current system were taken to not just identify the number, but to see what could then be done about that number?
That was part of the fundamental review that was carried out in 12-13. We knew that the current regulatory system wasn't sufficient to regulate HMOs, and we could see the problems that were arising in various areas, particularly Holy Lands. So that is why we've got to the stage we're at now with the new bill, and to introduce a lot of the changes which are taken from best practices in other jurisdictions.
Right. But, I mean, are you confident that not just the 500 that aren't currently registered, but the issues that may well arise given the demographic changes that you're anticipating, understandably, with the University of Ulster in Belfast, that there isn't going to be as much of a loophole, a 10% loophole approximately there? And that just looks to me to be very round figured. You have approximately 30,000 people and approximately 500 not registered.
Sorry.
But even that, that left a sort of a 10% approximate number of people that weren't registered under the current system. Given the additional difficulties, how confident are you that that figure's not going to get worse that 10%?
Okay. Part of the problem at the minute is, and this is a weakness, that it's not actually illegal to operate an HMO without being registered, because there's a registration plan that the housing executive have. So you can be operating an HMO perfectly legally and not be registered, because it's there's a kind of process. You don't have to be registered before operating. The licensing system will mean that you will be acting illegally if you're not licensed before you begin to operate an HMO, and that's a fundamental change. So it just changes the whole dynamic, and what we found, for example, with landlord registration, was there was a sense that many landlords wouldn't register. Actually, we're fairly confident that the vast majority of landlords have registered and have abided by the law. Part of the difficulty at the minute is that the definition around HMOs is a bit woolly. This bill will make it much clearer what an HMO is, and will require those landlords to register before they operate as an HMO. So that should address a lot of the issues. And if people still evade the law, knowing that they should be registered, there are proper enforcement powers for councils to challenge them.
Yeah. Just on that, I mean, you had said before about the sort of graduated response in terms of, whether it was fixed penalty notice and then eventually going to court. Given the current, what I think most people would look at, relatively derisory element of average fine, less than £300, have you taken account of that as well as the Scottish experience, or what have you taken account of to sort of allow for any degree of fixed penalty element which would be sufficiently punitive to try and ensure that you won't have a whole raft of cases to pursue through the courts?
Well, the offences, I only really mentioned the more serious of the offences, but they are graduated, and they're all on the standard scale, which is a legislative term for penalties and fines. So we have a four-tier approach, with the lowest being failure to comply with information, for example, and you'd be subject on a conviction in court to £500, whereas the fixed penalty notice for that would be £250. So that's
Is that 500 or up to 500?
up to 500, sorry, up to 500.
Yeah, but the current fine is up to 20,000.
Yes, but
the average
that's
is 290.
Yeah, and those fines could be for one of the more serious offences, and that's a very lower tier. Whereas we're going up to a maximum of £20,000 in court. Whereas our fixed penalty notice, straight away, if an inspector went out to a property and found that there was something untoward, they could serve a fixed penalty notice on that day for £5,000.
I think one of the other things that's worth saying is it would be quite difficult for a court, if a fixed penalty notice, for example, is for acting in an unlicensed way is £5,000, it would be difficult for a court to give a fine lower than that. In a way, this will help to act as a guide to judges to say, this is the expectation of the legislature, that this will almost become a kind of guide for them as well. So if cases do get to court, that should
a benchmark.
Yes, it should help to improve.
Coming back to your previous point about the unregistered HMOs as well, because maybe it's perceived by the public and maybe some unscrupulous landlords that it's fairly toothless at the minute, and there is no real penalties for not registering. Whereas with this more robust system as well, they will know straight away that sort of stuff won't be tolerated anymore, and that there won't be the flexibility for them to get away with it. As Stephen mentioned as well, because they have to be licensed before operating rather than coming after, it means then that all that has to be set out at the outset, and they know that really there's no room for manoeuvre and everybody has to adhere to the same rules.
Okay.
Stuart?
Thank you, Chair. Can I just raise a few issues around the fixed proper persons with you? But maybe just before we do that, you made reference to Belfast Council and also to Causeway. Yeah. Perhaps a changing dynamic, but nevertheless, both Antrim, Newton Abbey and Mid and East Antrim will have had, I'm thinking particularly of Jordanstown and also Carrickfergus, where there are a number of properties in multiple occupation, primarily because of the Jordanstown location. So I think it's important that you recognise that there are other councils that have that within their aegis at the moment. With regards to fit and proper persons, the sort of standard thing that happens in these sort of things is that landlords can, maybe the landlord isn't the fit and proper person, but they then put the business or the property in the name of their wife or their partner or vice versa. How will the legislation deal with that? And, you know, are we really going to get to what is a fit and proper person, or are they just going to be able to duck and dive and dodge around that as a result of this? A couple of other things. Probably, certainly in the public's mind, from a health and safety perspective, I know the public's mind quite often can be around antisocial behaviour and other things, but one of the things in the public's mind regularly is health and safety, or health and safety issues, and particularly that around gas, appliances. And we've seen a number of incredible tragedies in respect of that, and particularly if some of these HMOs will be young people, particularly students, those tragedies are multiplied by the number of people, or can be multiplied by the number of people in a property. To what extent will the local authority be required to do additional checks prior to occupation of the property, and then to ensure that appropriate statutory checks are followed through? In other words, the annual gas check, or that it comes along at the time when tenants change, because tenants can sometimes leave a property not in appropriate order, and therefore is there an obligation on the landlord to ensure that if on a tenancy change that all of the checks are re-envisaged with regards to that. And the other thing I wanted to ask you about was in relation to the joined up aspect, and I do welcome the fact that it will be a local authority responsibility, but I just have some concern that even though it is a local authority responsibility, that health and safety, that inspection and the planning, that there needs to be some direction to ensure that that is joined up inside the local authority and that they're not operating in silos. You know, we're at the extremely early days of the new local authorities, and one of the great fears and one of the great realities of public bodies is that they do tend to operate in silos and there is no cross cooperation. So we need to ensure that that is protected, or that is a requirement, that there is a cross flow of information, and that there needs to be a paper or electronic trail that demonstrates that one bit has spoken to the other, and that the documentation has moved between them all. Are you also satisfied that tenant rights are covered in this, or are they covered separately in respect of those people who are occupying the property? This is all about the owners of the property, but is there any cross-reference again to ensure that the owner provides appropriate tenant rights for the people in the property? And finally, you make reference in the just in the guide in the note that we have, where a person has been found guilty of unlawful discrimination grounds of sex, colour, race, ethnic or national origins. You don't say sex or sexual orientation. Is that implied or not?
Okay, if I can
do in relation to race.
Okay, if I can start with the question just about join up, and then I'll bring in colleagues. In terms of join up, I mean, I suppose we're trying to do two things. We can't mandate that in law that a council joins up. I think that's about discussion and about management. So one of the things that we're very keen to talk to councils about is how they plan to administer this function, and that's the conversation that we started to have with Belfast, and I take the point we need to have with others. What we will also be doing is sharing our experiences from Scotland, where similarly councils have responsibility for planning, etc. So one of the things that we will be offering to local authorities is to bring somebody from Scotland over to share experiences. So it'll be about sharing experiences, good practice, but ultimately it'll be up to councils how they administer, but we'll certainly try and point them in the right direction. David, do you want to pick up some of the others?
Yeah, in relation to your first question, in relation to the fit and proper person, any person that would be carrying out a managing role in relation to that HMO would be required to undertake a fit and proper person test. So it could be anyone from that's taking the money, that's organising the tenancy agreement or whatever, and that's in contact with those tenants that are in the accommodation.
But you do understand that what can happen is that the person that you check as being fit and proper person may not actually be the person who on a day-to-day basis is the person who relates to the tenant, and therefore...
Yeah. We envisage that there'll be an application form, and the application form for a licence will entail the landlord's name and any other managing agents that may have contact. Now, if it is found that a person is working as a managing agent, that is a breach of the licence, so that then would fall to prosecution or to fixed penalty. Another question you asked in relation to...
Good stuff, exactly.
Is that okay?
Well, yeah, but John, at this point there again.
No, I was just saying the licensee could still be the wife of the person with the relevant conviction.
If that person was carrying out a management role, they would have to be named on the application form and would have to undergo a fit and proper person test.
But they could be the licensee and effectively take no part in the business.
I think what David's saying is if that were the case, and a council found that somebody who was not named on the fit and proper person process was having a management role in relation to an HMO, that would be an offence.
No, that's the opposite end of the proposition. If someone is the licensee for the purpose of getting the licence, but takes no part in the business, they've ticked the box in terms of being a fit person.
Yes, but I think, as David said, that if anybody involved in the management of the HMO needs to be named on the application and go through the process. If anybody is found then to be involved in the management that has not been named in that process and therefore checked, that is a breach of the licensing conditions.
But it wouldn't be a breach because you've got a clean record. Be the paper licensee, take nothing to do with the business whatsoever, and the business carries on in your no name.
The advice that we've got, I mean, the way that we set up the system is that if I am the licensee but Ronan and David are involved in the management of the HMO, if they are not named on that certificate, then and they are involved in the management, then I will have been checked, they will have been checked. But if Ronan's not named, for example, and he's not deemed a fit and proper person, then and he's involved in the management, then an offence is created because he is involved in the management of the HMO, but he is not named on that.
So you lose the licence because you haven't named him, is that what you're saying?
Well, you could, yes, you would be acting in breach, so potentially you
could lose your licence. Yeah.
But how far do you drill down to managing a property? You know, the property can be managed at a whole range of levels, right down to the person who cuts the grass outside. Do they have to be a fit and proper person? If the tenant goes to them and says, "Look, you haven't cut my grass for 6 weeks," and this guy says, "Well, not doing it," or they get into an argument or a row and then a complaint is made, is that person part of the management structure? If they're perhaps the son or daughter or in-laws or outlaws of somebody who's the owner of the property?
Essentially, the way we saw this working was we looked at the other jurisdictions, and both England and Wales and Scotland have fit and proper person in as standard for HMOs. So
that's just the front.
I understand. So obviously we think we're slightly behind the ball in that respect. Now, fit and proper person is looked at in the current registration scheme, but it's not involved in the legislation, so it's not really enforceable. So what really the concept behind fit and proper person is getting somebody that you're confident will run a property and maintain a property and stick to the regulations. So we have to bring it in, and you have to make it flexible enough that and still protect the housing market as well, in that there's HMOs that offer a very valuable source of housing to people out there. So when we looked at it, we didn't want to take away from the current housing market. We don't know how many people might not pass this fit and proper person test who are actually currently HMO landlords. So we had to build in something there where they could have an agent who would manage it on their behalf if they didn't pass. Now, if something goes wrong during the duration of their licence, where there's a breach of the licence or something, both the owner and the agent will be subject to offences and penalties. So it's a twofold, it's a two-pronged approach, because we're trying to get around that where the scenario you said that the person doesn't pass the fit and proper person test and maybe gives it to their wife. Their wife has no active running in it. Now, if that falls into disrepair or there's something that the tenants don't do, both the agent, who is the wife, will be subject to penalties, and the owner, because they've knowingly allowed that to happen.
I think we'll monitor that further when it comes back to it. Sorry, go on.
You also asked the question in relation to statutory checks
Yes.
for HMOs.
Yeah.
There are new, the bill will introduce new standards and management checks, and a lot of that will be dealt with in the regulations coming outside of the bill. And of course, that'll follow on then with guidance for both the landlords and
But will that come with, for example, a change of tenancy or change of tenants within?
It will, because if there's a change of tenants or a change in owner, if change in owner will have to apply for a licence.
Sure. Yeah.
Change in tenants, then there's different ways and means of contacting, of getting literature out there for tenants to be aware of the situation, particularly through universities, and we also have newsletters and whatever that we would publish.
We have in the primary legislation a code of practice, so the detail of that will be in the regulations. As you mentioned before, the gas aspect and carbon monoxide, that will play a big part of it. We will obviously have to drill down the detail about that. But you also mentioned about the tenants and what they'll take out of that.
Yes.
As part of management conditions for the landlord or the owner of the HMO will be an occupancy agreement. So that will lay out exactly what the landlord has to do in respect of the tenant, and vice versa, what the tenant will have to do.
Yeah.
So we couldn't build an awful lot of antisocial behaviour aspect into this, because our powers are very limited. But at the same time, if a tenant did something that resulted in a breach of licence themselves, then that could be a breach of the occupancy agreement as well. The same thing as in normal private rented.
Okay.
So basically it just allows that both the tenant and the landlord will know their rights and responsibilities at the very outset of any occupancy being taken up.
There's one final point about about sexual orientation.
Right.
I think that piece was drawn from the legislation.
So that's
So I assume, we can double check, but I assume then that is not, that sexual orientation is not currently a part of that equality legislation in terms of letting of properties, but we'll check on that and come back to the slide.
Thank you.
Okay, Roy, and then Jim.
Okay. You've indicated in your briefing that whilst the maximum current fine is £20,000 for failures, there's only been 97 prosecutions, and the average fine imposed by the court is £292, which is a long way off the maximum, and yet we all know there's been some fairly serious situations. Have you made any representations in terms of the review process through the justice system that the bench should be reflecting on the level of fines in this area?
Yeah, I mean, I think the judiciary quite rightly guard their independence very carefully, so we certainly would normally include the Lord Chief Justice as part of our consultation arrangements, but we have no authority to direct the Lord Chief Justice. I think the important thing is that if this bill is passed, with the subsequent regulations that set out the fixed penalty notices and the expectations, that creates that is the legislative expectation of the system. So that will help to inform, but we have no authority to direct the judiciary.
But yet, if there is public concern about the level of fines in any particular area, there are mechanisms of making the judiciary aware of that, not in individual cases, but just the overall run of things. So I would ask you perhaps to consider pursuing that one as well. In terms of fixed penalty, I have to say I would be supportive of it in principle. I've come across an issue where there's been huge expense to police, to local authorities. It was to do with ASBO. I ended up being a prosecution witness. Huge expense to the police to local government. And in fact, there were the original case, then there was appeal. The appeal then got abandoned halfway through. So there's 3 court cases, all paid for by public expense because of unreasonable behaviour of an individual. And that was causing huge amount of money and huge resources for the public. So if there are better mechanisms, we should be looking at them. So I would be generally supportive of the concept. But how are we going to ensure that they're not going to be abused by, and that common sense is, they're going to be used in a sensible manner?
I think councils have shown already. They operate a range of fixed penalty systems in the private rented sector for dog filing, for a range of offences, and I think they have demonstrated that they act in a responsible manner and a proportionate manner. So, we have no concerns about how they might operate that system, and we agree with you that it is likely to be a very useful incentive or deterrent for behaviour.
And for getting speedy results as
Yes.
well, I think, for the tenants' interests. In terms of HMOs, and as in paragraph 10 in your briefing, 17 in your briefing, you've indicated that buildings or parts of buildings which are considered not HMOs are listed in the schedule, and in that you've included if it's owner occupied. So does that mean if an owner is in a building which is vastly overcrowded, that he could be excluded from HMO guidance?
I think that the key thing that we're trying to do here is focus on risk. The key risks are around rented housing, because there's no. This is where there is no head of household, and therefore the risk tends to be greater around safety, particularly, and some of the documented cases from the past have been exactly that. So, no, and I think our view is that it wouldn't be appropriate to apply the same level of regulation because there isn't the same level of risk in owner-occupied properties, and that's the basis on which we've drafted the bill.
My degree of concern is the unscrupulous person that your legislation is designed to keep out of the system. They might say, I'm living in this building, and yet it's overcrowded, and it's not maintained right, and the gas boiler is not serviced, and they say, I live in this building. And so you have no role for our local government has no role to impact on that?
Well, they would be caught because they'd be renting then. They'd be renting parts of the, and so those would be addressed. Somebody trying to masquerade as an owner in that situation would be subject to the.
We would envisage the council would be carrying out their checks, and if they had reason to believe that an owner was perhaps living in that accommodation, they could use the shared information services in order to check, and perhaps they would be able to find whether that was the case.
But certainly if that was the case in that scenario, that house could be subject to HMO regulation.
Yeah.
Great, and then the other exclusion you've given is if it's occupied by persons who form 2 different households. Can you explain why you're wanting that as an exclusion? Again, there could be serious overcrowding in one part of the building, and perhaps even with a separate boiler system, who knows? So why are you using that as an exclusion?
Sorry, what was the exclusion?
If it's occupied by persons who form 2 households.
That's carried forward from the current legislation. There's 2 aspects we looked at within the definition, and one is that the person has to be occupying a building or part of a building as their main residence. So that's the physical structure, and then it was the makeup of people within that. So what we wanted to capture were if there were multiple people in the property who were unrelated to one another. So that's what that really means. So a family in there would obviously. Class as one household, whereas 3 students would class as 3 separate households, even though there may be less people in them. So
you're excluding if there's 2 households. It could be two different families, one family in one nice bit of the building and another family.
Say your mother-in-law was living with you.
Pardon?
Say your mother-in-law was living with you.
That's part of the same family.
Definitely regulation.
And she has, and that could be part of the same family.
I think it's going.
It's worth a candle.
It's going back to what Stephen said earlier. I think it's identifying the risk and where the risk would be and what type of houses. And normally, you know, looking at the definition, the highest risk, the greatest risk that you get is the greatest volume of people living in the address and not having a head of household, whereby if you look at it, the equivalent of owner-occupiers, what we talked about, owner-occupiers, as you talked about earlier on, there's an individual person that's taking responsibility. 2 families, you've still got a head of household in the 2 families.
I'm just, I'm conscious of some media stories that there have been of severe overcrowding of perhaps 2 families in a very small house,
Yeah,
and yet that could potentially.
As I
be
said before,
implemented.
it's brought through from the current legislation, and our rationale behind that was we want to capture the same sort of houses because we've taken into account the Northern Ireland breakdown of HMOs. In relation to overcrowding, if there's 2 households, and even though that's not a HMO by definition, there are other notices that the council could issue under public health that would maybe deal with overcrowding. But for
So
those,
you said maybe would they deal with it?
well, there are. Yeah, there are. It depends. You know, I'm not au fait with the overcrowding.
We'll check the situation out, but basically what we tried to do, as with all things, we're trying to strike a balance and trying to focus on areas of greatest risk. I mean, we were taken to judicial review about 8 or 9 years ago on the definition, and it was this exact issue, and the judge reasonably said that the law should not be trying to interfere in somebody's right to peaceful enjoyment of their property, and challenged us on this issue of owner occupation and the number of families. So what we tried to do is strike a balance to focus this legislation where people are at risk, and to leave people who are a much lower risk, owner occupier and so on, to enjoy their homes peacefully. Now, if we haven't got the balance right, that's something obviously that we'll look at, but that's what we tried to do. We strive to strike this balance.
Okay, reasonable explanation. Thank you.
All right, thank you. Stuart, do you want to back in?
One very brief question. Will there be a fee charged for the fit and proper person application?
There's a fee for licensing. Yes, there will be a fee for licensing. Our intention is to keep it at the same for the initial period as the HMO registration fee, which I think is £500, is it?
It's £25 per person.
£25 per person per year. But so we're keeping it. We're keeping it at the same level. But it will be a fee for licensing rather than a separate fee for a fit and proper person.
And will that be a fee? That fee will be paid to the local authority then?
Yes, and retained by
And will they have the power to change the fee, or is that?
No, that's the power that will be set in regulations for us to be able to change through regulations.
But it's clearly not a cost recovery fee.
It pays for some of the administration of the scheme, but not the totality. And our aim over time would be to increase it to such that it does cover the.
Sorry, apologies, Chair. Thank
2 further queries, Jim, before bringing yourself in. One from Roy, one for Fraz.
Just very briefly, the fixed penalty fees, will councils be able to retain that to try and keep their overall cost of administering the scheme down?
Yes.
Okay, thank you.
And again, it's in relation to the charge for the licence. How does that match the private rented sector when that has been brought on under the registration scheme?
The registration scheme is a one-off fee of £70 that lasts for 3 years. Isn't that 3 years? Yeah. HMOs is an amount per tenant. There's a formula for calculating it.
It's £25 per tenant.
And the aim of both, in theory, is that the cost of running the scheme is self-funding. For landlord registration, that's the case, and that's why we set the fee at £70. For HMOs, there's a lot more intense work because there's the inspection process and so on. So, in theory, the fee should fund the scheme. It doesn't, and that's why over time we want to increase the fee so it does. So it's slightly different from landlord registration, and that's.
To take it this, was this different from what occurred in other jurisdictions?
The HMO fee.
Yeah.
I think it's just developed over time, and we keep an eye on what happens in other jurisdictions. But because we don't have licensing, unlike Scotland and England and Wales, we don't have a licensing system. We have a registration system. It's not a.
I think you indicate there in your. I think from England, if I understood England and Wales, the fee would vary from council to council, given some councils have a much greater significant role in all of this. All right, Jim.
Just a couple of quick points arising from paragraph 20 of your briefing. You recite, in regard to fit and proper person, any previous convictions relating to violence, sexual offences, drugs and fraud. In the bill, is that how it's going to be expressed? Is that the limit of the offending?
Oh, look. Proper person. Council must have regard to whether the person has committed any offence involving fraud or other dishonesty, violence, drugs, or a firearms offence within the meaning of the Firearms Northern Ireland Order 2004, an offence listed in Schedule 3 of the Sexual Offences Act, practised unlawful discrimination in or in connection with carrying out of any business, contravened any provision of law relating to housing or of landlord and tenant law, acted otherwise in accordance with the code of practice approved under Section 63, which is to be classified.
So, for example, would that include, there was a case not so long ago about gang mastering? Here, that wouldn't include that.
Yeah.
Or people smuggling.
We'll obviously need to check the detail of those committee on both those
I think
issues.
it's important.
They were
Aspects
certainly
of that
taken
are
into
covered.
account because in the information sharing we have built Gangmaster into taking into account migrant workforces and that sort of stuff who may find themselves in this sort of accommodation. We think is very important. Also, immigration enforcement. We've had dealings with them as well to try.
I think you probably need to include immigration offences.
Yeah, it may well be in there in the legislative language that I just can't.
Okay, two other points. Will the fit and proper person test be applied if it's a company that's running the premises to the directors of the company?
Yes, the short answer to that, yeah.
And I think I missed the answer because I got distracted when Sammy was asking you about spent convictions. Is it any previous conviction or is it any unspent previous conviction?
It's any offence is the way the legislation has termed it.
So a conviction at any time for any offence of that nature?
But it has regard to, once again, it's not.
Yes.
Councils have flexibility to take it into account, and the reason that we did this, we looked at the Scottish experience, because, for example, somebody perhaps who had a serious sexual offence 20 years ago is very different from somebody who had a shoplifting offence 20 years ago, and so we're trying to give councils enough discretion to, and really in this matter, to take account of those varying circumstances. Because that,
Yeah.
but there could be a spent conviction which is actually more.
You're talking about the rehabilitation of offenders order. Like any offence for which the penalty was less than 30 months can become spent. But you're not referring to that at all.
No, and that, no, we're not in this case, and the reason is really because we've drawn this power from Scotland, and they've taken the same approach, and generally in the application in Scotland there aren't that many people who fall foul of this because councils are able to use their discretion, but what they do is they apply quite reasonably the nature of the offence to the nature of the activity. So if it's a fairly minor offence and spent, they're obviously not going to take it into account. If it was a spent activity around, for example, drug activity or something, that might be much more relevant, and they would want to take reasonable consideration of that.
Okay, thank you.
Okay, members, thank you. There's no other members indicating to speak. Stephen and your colleagues. So, I mean, if you're happy enough, I mean, you've obviously taken on board a lot of issues there, and you've responded quite extensively to some of the issues. I'm going to take back some of the questions and concerns raised and for further consideration or clarity. So, if you're happy enough, then there's nothing else you need to say yourself this morning. You're happy enough that you've taken on board all what has been raised by the members so far. I look forward to outworking of your deliberations. Okay, so thanks very much, Stephen, Ronan and David. Thank you. Okay. Okay, members, moving into the next item, which is the regeneration bill. Okay, could I formally welcome Henry, yourself, Ian, and Anthony to the committee this morning again. If you want to please come forward to join the committee. Things, obviously, we went through the clause by clause on an informal basis at the last meeting a year ago. And we were waiting on, we had some amendments, some proposed amendments, and then the department were going to take it away for the minister's department's consideration. Now, I know we got a response back yesterday. I didn't even get a chance to read that because I didn't see it until later on last evening. And, so, I mean, what I was going to suggest here actually is that we would take the response to the concern of the proposed amendments yesterday from the officials. But certainly I would be uncomfortable sort of taking a decision today on some of this rather than taking a few days to reflect on it, because I'm literally only coming to this myself. I know some other members are in the same position. So what we'll do is we'll take the response first of all from the officials, from Henry and his team, but I certainly be inclined to consider then that we would take that information and then rather than go through the clause by clause today, then we would defer the matter until either Thursday or Tuesday, because you're really only talking about a couple of clauses, I suppose, but there may well be some consequentials. Or we can come back, I mean, I've raised this with the clerks, I mean, if we can come back equally as comfortably on Thursday next, and then do the clause by clause then when members have had an opportunity to consider the table papers and then the response from the officials here in person this morning. So in other words, what I'm suggesting, we take the information and then, as opposed to going through clause by clause here today, we would defer that until perhaps Tuesday or at our normal meeting next Thursday. We're still well within the time to do the formal clause by clause and do the report even the week after. So, I mean, if members are happy enough just to reflect on it for a few minutes, but Henry, you want to take the members through the response
Yes, okay.
from the Minister and the Department?
Okay, when the committee wrote to the department, and the department has now responded on the 5 issues raised, including a number of amendments. The first amendment was in relation to clause 1, and it effectively was removing the term social need and replacing with economic regeneration. The Minister, I think, accepts the general point, considers that the proposed amendments goes too far in that it would effectively remove the powers of council to address social need. And this would mean responsibility for this would remain with the department. This is out of line with what the executive agreed. The Minister has suggested put forward an alternative amendment at clause 1, which focuses more on regeneration, which is what the bill is all about, gives due prominence to economic and social regeneration, but also include addressing social need as one of the number of areas which can be financially supported under that new clause. And the clause is there set out in the brief, and obviously the committee will want to consider that clause against the clause that the committee recommended last time. In relation to clause, the second amendment, clause 2, to clause 1. The Minister has considered the concerns of members in relation to the decision of councils which could be politically contentious or divisive. But he's however decided not to accept the second proposed amendment in relation to the naming of projects. He had concerns about linking this provision to another piece of legislation which may be repealed or amended in the future with unintended effects on the regeneration bill. But he's asked for more time to consider this issue, and he will come back to the committee on that. In relation to the amendment suggested in the publication of notices in the paper and extending that to include publication on the website, the Minister has accepted the committee's proposal and will bring forward necessary amendments at consideration stage. And they're also set out in the response to the committee. The issue of councils working together on development schemes, Again, we sort of reiterate the point about development schemes the development power has been used very infrequently, and how often the department has used them in the past. There's nothing in this bill to preclude councils from working together on development schemes, and the department would actively encourage that, and that will be set out in guidance from the department. Indeed, the Local Government Act provides for 2 or more councils to work jointly on issues and projects. The last point then is related to monitoring arrangements, and the Minister's noted the concerns of the committee and wishes to assure the committee that he will put in place appropriate and proportionate arrangements for monitoring how councils carry out their new responsibilities under the Regeneration Bill. Those are the 5 areas which were raised by the committee.
Okay. Henry, thank you. Roy, then Sammy.
The legislation would allow council to do anything, and that could include very contentious issues. And at present, the proposed check, which was meant to be in local government, is not in place. Now, were such a bill ever to come forward and put that check in place, that bill could easily remove any clause within this bill which might be doing a duplicate piece of work. So there would not be duplication. You know, there's potential of actually solely having a one piece of legislation. So I'm still trying to understand why you would be opposing such a check to prevent contentious, significant amounts of public money being used for contentious issues.
This is the proposal for qualified majority voting.
Yeah.
I think that would be introduced under the Local Government Act by way of a regulation as opposed to another piece of primary legislation. So I'm not a legislation expert. I wouldn't be able to say exactly how that would work in practice. Whether you could actually remove a piece from primary legislation by way of regulation. But the other consideration with the qualified majority voting is actually a practical one as well. Most of the decisions that were taken under this bill would be fairly routine. In fact, most of the decisions that we've taken are fairly routine. But if everything that was to be funded under that clause had to be carried by a qualified majority voting, it would all have to be taken to every meeting of the full council and achieve 80% or plus of the votes of the council members. So there'd be no opportunity for the council to operate a scheme of delegation to committees or officers for smaller routine expenditures, and that might have the effect of making the process very inefficient and quite ineffective. So we need to take account of that possible unintended consequence when we're looking at that option.
Certainly, like the chair, I've only received this amendment as a tabled paper, and I would need more time to review it again. But I am concerned at the potential of significant amounts of ratepayers' money being used for contentious issues, and would need to review this matter further. And certainly, I think the committee should be trying to avoid that happening, because that will be very damaging to community relations were it to happen.
Okay, Sammy, then Jim.
Just 2 things. First of all, the reason that has been given for not accepting or for wanting to look again, that's one thing that has been totally rejected, the amendment about naming of specific projects. I don't quite understand. He is concerned about the explicit linking of the provision to another piece of legislation which may in the future be repealed or amended in a way which has unintended consequences on the Regeneration Bill. What exactly is meant by that? I'm confused by it.
The proposed amendment would be that no project could be named, that would be funded under that clause, could be named by any person which would be covered by the provisions of the Civil Service Act, the Special Advisors Act that was passed.
It could be named after anyone with serious criminal conviction.
Yeah, as defined.
As defined, because that's where it is defined.
Yeah. So we understand at this point what that means and what kind of person has been covered by that legislation, but that legislation could actually be changed at some point in the future in a way we can't predict. and you would end up with a situation where the provisions actually are different. So now, what the Minister's concerned to make sure is that there is he understands the nature of the concerns that have been expressed, and he wants to have a look at that. And he's also aware of a case where there's a contentious issue about the naming of a project in a town, but the individual concerned has never been convicted of any offence. And so the question is, that is still quite a deeply contentious issue in that particular town. So he wants to make sure that whatever provision is put in is actually sufficient to cover the range of circumstances which these kinds of things can happen. So and the issue of the Raymond McCreesh Park in Newry was raised at the committee previously. Whilst the proposed amendment would cover that, it would not cover the issue in Strabane, where the naming of the bridges become contentious, and that's had some exposure in the media as well. So he wants to try to find a way to ensure that the naming of projects does not become contentious or difficult in those towns, but will cover the range of circumstances in which that might happen, but be reasonably capable of being well defined and easy to apply.
So, I mean, really, you're saying that the amendment as it was proposed last time, he feels is not wide enough to cover all the circumstances? Now, I don't think there's any difficulty with, I mean, it'll be interesting to see what amendment the department then comes back with on that. Just on the inclusion of the social need aspect, we'll have a long discussion on this the last time. You know, economic regeneration, I think we've already accepted, is designed to address social issues anyway and social need. And it just seems to me, seeing you put in that this bill is about, it's a regeneration bill, but then we put in that it's also a social regeneration bill. I mean, it's either one or the other. It can't be both. Or if it's going to be both, then why is it not called an economic and social regeneration bill? And I still come back to the point that I made the last time, that once you put that in, and once you emphasise the social need aspect, then you still you have that problem of where regeneration might be outside an area of social need, but actually have a huge impact on a better impact on the area of social need than locating the activities or the regeneration within that area. And we mentioned, you know, places like Carrick Town Centre and the effect on Glenfield or Castlemar or whatever, and we're probably more effective to put the money in there. Now, I don't see how the changes which have been made do away with that particular problem.
The previous wording was that the financial assistance would be provided to do anything which the council considers would address social need in a district in this area. I think the wording now is much wider. There's not in the past been any issue about us funding projects in, for example, town centres, which under the social needs order, for example, we fund public realm schemes and environmental improvements there and urban development grants in those locations without encountering any real difficulty with the legislation. The issue about addressing social need is if the amendment as had been proposed by the committee previously was to go forward, it would not be possible for the department to transfer responsibility for the community development activities that it currently carries out to local government, and substantial parts of the kinds of activity we do under neighbourhood renewal wouldn't be possible. So, for example, just to pick out a couple of cases, we have funded quite successful projects, nurture units in primary schools in a number of locations, and those have now been mainstreamed by the Department of Education under the form of the bill that had been suggested by the committee previously. It wouldn't be possible to fund that kind of project because there's no link between it and economic regeneration, although it does actually address a social need and pursues social outcomes which are beneficial. So we wanted to make sure that the councils would be capable of covering the full range of stuff that the department currently does, and that we weren't left contrary to the Executive's decision, holding responsibility for certain areas of work which were to be transferred, and at the same time allowing the councils to take forward the full range of kind of activities that they might want.
Why would that not come under economic regeneration, for example? You know, I'm not too sure what actually went on in all the nurture units, but I imagine that it would improve the employability of the mothers. You know, to have such a facility within the primary school, it would maybe even free up mothers at an earlier stage of the day or later stage of the day. How does that come under economic regeneration?
It's not a childcare project in the sense, but the kinds of projects that we fund in childcare do have those kind of economic outcomes. Now, a nurture unit is where a child has a particular emotional or behavioural difficulty, which means that they aren't capable really of learning. And this generally tends to be children in primaries 1 to 3, and they are taken out to a special unit where they're helped to overcome those emotional and behavioural issues. So a very successful run was run in Ballysally Primary School in Coleraine for a number of years, and they had been experiencing a rate of special needs referrals for emotional behavioural difficulties of about 3 or 4 per year on a consistent basis. And once the nurture unit was put in place, a significant difference was made, so they haven't had a single referral for that region since the nurture unit opened. Now, it would be a very tenuous argument, I think, and quite a convoluted one, to take a 5-year-old child and do something with them in a nurture unit and then have a very long chain of causation get to a point where there's an economic regeneration impact from that particular project. It's an argument you can make, but it is quite a lengthy and tenuous one, and we wouldn't want to see a situation where every single project had to go through that kind of very convoluted argumentation to get to a point where it could be funded.
Haven't you forgotten cause 2D?
2D?
Yeah. The provision of social or community facilities. What's taking that out?
That's not a facility. The nurture unit is not a facility in itself. It's
what is it?
Well, okay, it's a room in a school. There previously, we haven't funded the creation of the room. What we're funding into these projects is actually the salary of a teacher, a specialist teacher who works with the children.
Well, that's a facility for the community, surely.
Again, I think that's my concern there with that wouldn't be. It's quite a convoluted argument has to be made to support those kinds of projects, and it's not immediately apparent that it is directly allowable under that. So this.
So when you consider some of the things which were possible under the social need order, like money to the Bloody Sunday Trust, like money to ex-prisoners groups. There didn't seem to be much difficulty on the same language. This is a lift from the 86 order of working out in a fairly elastic form what social or community facilities were.
The issue that allowed, or the point that allowed that kind of project to be supported was in fact the what you, I think, previously termed the catch-all clause that came at the end of clause 1, part 2, which is now, I think you'll see it's not there anymore. So the provision that allowed for the funding of that kind of project is no longer there.
Yeah, but does social need not have the same elasticity as the previous, the phrase which we had asked to be taken out? I mean, and that's the whole point. That, you know, it was the catch-all phrase at the end was the one which many people queried and said, what has this got to do with regeneration of a community? But if the catch-all phrase has simply been replaced with what you've described as F,
Please, I can't hear the figures.
is what you've described as F, then, you know, we're no further forward.
Well, again, I go back to the point we have to. The department feels that we need to try and strike a balance between allowing the councils to have the ability to come up with projects which will meet need, which may not, you know, innovative approaches which may not have been tried before or identified before, but at the same time making sure there's sufficient control for what there's a balance has to be struck here. Now, if it's the committee's view that they would rather constrain the activities of the councils rather than allow that degree of flexibility, then that is what will be, you'll no doubt take forward as in the proposed amendment to consideration stage. However, having have to caution that this would be, would mean that the executive's decision in relation to what should transfer from DSD to local government could not be carried forward in full, and that would be, have a policy impact, and then therefore we need to work out what the implications of that would be. It would leave quite a swathe of activity in the department which was intended to have been transferred by the executive.
I think in fairness, I mean, you're putting that quite firmly, I would suggest, and I think that's what needs to be done, because we could go around the houses here, and we can do, obviously it's up to members to raise whatever issue they want, but what we're trying to do here is to establish is that the kind of proposed amendment, albeit on an informal basis to the last meeting, but the Minister has given us a response to that, and I would suggest this point is probably of us going around the house here arguing the validity of the concept of economic regeneration as against social need. They don't need to be against it. This is about trying to get an accommodation, and the Minister made a proposal to us. So, I mean, I would suggest that unless there's any further clarity that we really need in response to, in relation to the Minister's response, I think we do need to go away and reflect on this. But I mean, I won't take all the members, but I'm just simply saying is it really is about trying to clarify what do we think that the Minister's response resolves our concern or not. No point rehearsing all of the arguments which resulted in the proposal in the first place. And then was just how we would defer this then until the next week. Jim, you're looking at.
Yeah, I'll not labour the point, but I very much agree with the line that Sammy Wilson was putting to you. It seems to me that by adding back in point F, by putting point F in, you've just brought us back to square one in terms of the problems that some of us foresaw with the elasticity and the potential abuse of the matter. So I think that that's a particular difficulty for me still. I want to ask, what's the definition of social regeneration?
It is anything which will address social problems in a neighbourhood or an area. So that might be to improve health outcomes or educational outcomes or reduce crime.
Is that defined somewhere?
Well, that's the understanding that we have used in the department. I don't believe it's defined in legislation anywhere.
And it's what the Minister is proposing is economic or social regeneration, not and or.
Yes.
And you have my point that I think F just takes us back to where we started. On the second amendment, the Minister says that you can't really do this because it relies on a definition in another piece of legislation. What does section 4, clause 14 of this bill do? It relies on definitions in other pieces of legislation. That's very common in any bill.
Yeah. Well, I think, as I said in response to Mr. Wilson, that's only one part of the concern he has. I think it may well be that his concern is more that the definition in the other bill that's referenced here is actually more narrow than he would like.
He wishes. Yeah. So when's he going to return to us? Because it says we'll revert to us with his decision.
Couldn't say.
Well, like we're talking about meeting Tuesday, Thursday, are we going to know?
I couldn't say, but he'll have to consider what he wants to do in relation to that.
But he must know the confines that the committee's operating under, that we have a cut-off date of the 28th, I think.
Yeah. Oh, yes, he understands.
Which means that we've one further regular meeting before that date.
Yes.
So if the committee were to decide, say, to meet on Tuesday, would we have an answer?
We will reinforce to him the need to get this matter dealt with before that happens in order to get the process concluded. I can't tell you what's in the Minister's mind. I can only tell you what he's told.
I see.
Okay. Okay, look, there's no other members asking any further questions. And Henry, you've already outlined, you've went through the Minister's response to a number of issues which are raised, most of which or because I'll be happy enough with the responses, but clearly we'll deal with that when we go through clause by clause anyway. Can I thank yourselves then for being here this morning, and I suggest, members, then we defer this matter until next Thursday, just to allow the maximum
Could I
time.
just make one point? It's a selfish point, I appreciate, but you had suggested Tuesday. There's a particular reason why I can't be here next Thursday, and I've quite an interest in this bill from the outset. If Tuesday were a possibility, I'd be grateful.
I mean, I'm happy enough if people content to come back on Tuesday, because I don't think there's going to be a huge amount of debate required.
No.
Who knows, but
If it were Tuesday, are we talking about morning? What we normally do if we're going Tuesday, yeah?
Morning or lunch?
Or lunchtime?
Or lunchtime, yeah, that's it.
okay, so lunchtime, you think?
Just members.
12:30 or whatever.
12:30? Okay, and is that okay? George, do you have no problem?
Just at 12:30, sorry, apologies,
Are you
sir,
business
but at 12:30, the business committee meets every Tuesday,
1 o'clock.
so
1 o'clock.
1 o'clock.
would be fine, thank you.
1 o'clock?
You suggest 1 o'clock, or?
Thanks.
1 o'clock?
Any advance on 1
Any
o'clock?
advance to 1 o'clock? Okay. 1 o'clock it is. All right.
See you then.
If you're not here, bring a note to next meeting. All right. Okay, members. Okay, moving on to our next item, which is proposed subordinate legislation. Okay, so this is the occupational and personal pension schemes, automatic enrolment amendment regulations, Northern Ireland 2015. So this is on page 35 of your pack. And as you know, the department proposed to make a statutory rule which makes technical amendments to the occupational and personal pension schemes, automatic enrolment regulations. Subject to negative resolution procedure, I propose that the rule will be brought into operation as soon as practical after royal consent. Are members content for the rule to be made?
Great.
Okay, members, thank you. Okay, moving on to correspondence, a couple of items. Just to bring your attention to correspondence from the Minister, that's on page 44, and that's regarding the committee's decision to publish the redacted fact-finding report in its phase 3 report of the inquiry. Let's just remind ourselves that at the meeting on the 26th of February, it was agreed to publish a redacted version of the report. This report was included in the committee's minutes, so those minutes were available from the website from the 6th of March, but I mean, I will respond accordingly to the Minister. Okay, so we also have correspondence from Unison on page 101, and that's in relation to the presentation they did in relation to Apex. And we also have correspondence from Apex at page 103. Obviously, that meeting was recorded. There was information. There was a public session. There was quite a bit of a problem with that particular session because some of the comments were made by those making the presentation caused concern with Apex, because there were allegations and statements being made which hadn't been apparently addressed in the appropriate structural manner with the housing association itself. So, but since that's been already done, we're suggesting here that all we can do is really put up the correspondence on the committee website. I actually thought it was ridiculous the way in which the delegation, I spoke to some of the people in that who were on the presentation, but people close to them, and they were, in my opinion, they were, I would say, probably inadvertently misled as to the nature of the presentation we're coming here to make. Because we clearly understood that we're coming here to talk about the working terms and conditions for staff within the community voluntary sector, and it turned into a whole other set of problems been addressed that hadn't apparently been addressed appropriately. So caused difficulty for some of the people who were involved here, who were under different apprehension or different understandings to why they were here in the first place. So, okay, so we just publish them on our website. Okay, thank you for that. Okay, and just again a further item on this page 18 of the tabled items folder, and this is a letter from IMTAC, and they've written to ourselves to express concerns in relation to the licensing of pavement cafes, in particular the recommendations made by IMTAC to DSD on guidance regarding pavement widths and enclosures of cafes. I just want to ask members if we're content on behalf of the committee to write to the department to seek a copy of the draft guidance.
Yeah.
Yes, okay, members, thank you for that. Okay, and members then content with the rest of the correspondence outlined to be dealt with by per the memo on page 42 of your meeting pack. Yep. Right. Okay, members, thank you for that. Then the corporate work programme, aside from the meeting then on Tuesday next, then members content with the corporate work programme is drafted. Okay, anything under AOB?
Mr. Chair, just following on the debate this week in respect of the committee report, what action does the committee now propose to take, given that the Assembly has accepted the report, to ensure that its recommendations are implemented?
Well, it was a take-note debate, and that was accepted by Assembly, and I was going to suggest that at least we, although it's public and it's been debated and heard, but I would presume that we should be at least formally sending a copy to those organisations, including, for example, Malcolm McKibben, because at that we have made recommendations. So anyone to whom any of the recommendations or conclusions refer to, I think we should send them formally a copy. I think they're
Is there also value, Chair, in providing a copy to the PSNI to let them peruse the report as well?
difficulty himself. We were advised by the Minister that he would respond within 8 weeks. That's of help, so that's the Minister responding, so there are others. So I'd be happy enough to, sorry Roy, go ahead.
I mean, the other issue that came to light was essentially there's no governance over SPADs, and one of the recommendations was that the Assembly Executive should address that. Should we be sending a copy to the Assembly and Executive Review Committee? How is it going to get addressed?
I mean, I'd raised this with Kevin, actually, just in anticipation of this kind of discussion, you know, so obviously there's the standards and privileges, there's a Commissioner for Complaints and so on and so forth, but that's why I was just suggesting almost generically there, because a lot of those organisations or agencies or whatever you may call them probably will say thanks very much and we'll get back to you or will not even respond. I mean, I can't imagine, I may be entirely wrong, I can't imagine First and Deputy First Minister's Office responding, for example. I may be wrong, but...
You're wrong.
You're wrong.
No, you're not.
So, what I mean, all I'm suggesting is that we would take the report and send it to those organisations who may have some interest or role, particularly, as I've said, people like the civil service and so on like that. But anybody else, and I have no difficulty.
Relevant committees.
Because it's a public document, so we should...
Malcolm McKibben would be, notionally, he'd have oversight of the SPADs.
That's correct. Yeah. No, I think it's very appropriate that we would do that. Okay, members. So on that basis, then the meeting stands adjourned next Tuesday at 1 p.m. Thank you very much. Thank you.